And hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content. And today will be the day I earn that subscription. For today's story, the Johnny Depp Amber Heard saga continues in the Court of Appeals of Virginia. Yes, both parties have appealed because both parties have judgment against them. Amber Heard, of course, has a judgment of like $10.3 million against her. But Johnny Depp also has a judgment against him of $2 million. And he has filed his appeal brief with respect to this issue. Now, the issue at play was Walterman, who was his lawyer, who made some statements. And one of those statements was found to be defamatory. I found this to be legally tenuous. I noted that under Virginia law, that it seemed to me that as his attorney, he was an independent contractor, not an employee. If he's an independent contractor, his statements, even if defamatory, could not be held to Johnny Depp. Only an employee, because that's respondeat superior, right? Your employee does something, you're responsible for it. But an independent contractor, of course, is not your employee. And I didn't think that it could be, I don't think he could be an employee. It's true that Waldman worked for him for a number of years on a number of different things, but I think he was an independent contractor, and so I found this to be legally tenuous. Well, that was my idea. So we're going to see to the degree to which Johnny Depp agrees with my idea and whether he has other ideas and try to evaluate it on its own merit. Will Johnny Depp have to pay this $2 million? Well, to find out, we're going to go consult the brief. In the Courts of Appeal of Virginia, in the case of Johnny Depp versus Amber Heard, this is the brief of Johnny Depp. Let's go ahead and get started with trying to understand this and what it has to say. All right, so we have a whole table of authorities, and so our argument is not so much because one, independent contractor. That's my principal idea too, so their attorneys and me agree that is the principal idea. Number two, present no evidence of actual malice. Okay. And number three, well, that's a little bit going to be legally harder, but we'll try. Number three, in context, the statements are not actionable. Also legally harder, but we'll try. Number one is your go-to, because it's just a pure issue of law, right? You don't need any facts. Like number B's and C's, B and C are potentially factually based issues, right? Whether or not in context are they malice, in context are they actionable? Well, that could be potentially intertwined with facts. But A is a pure legal issue. It's not intertwined with facts. If he's an independent contractor, the facts literally don't matter. That's what you want as an appellate lawyer. Like, it's your cleanest issue, right? If we win there, we're done. All right. So then we erred in the jury instructions. I noted some problems in the jury instructions during the trial. We went through those as well. And standard review. So let's go ahead and discuss all that stuff. All right. So we have some table of authorities. Always a good thing in your appellate brief. Some rules and statutes and all kinds of things. All right. Let's read the statement of the case. The appeal arises from a 6-week jury trial on competing claims for defamation. Johnny Depp alleged that Amber Heard defamed him by implying that in an op-ed of the Washington Post that he abused her during their relationship and brief marriage. Yes. By counterclaim, Ms. Heard alleged that one of Johnny Depp's attorneys, non-party admin Waldman, defamed her in 3 statements in the United Kingdom tabloid The Daily Mail, claiming that Ms. Heard's statements of abuse were false. She alleged that Depp was vicariously liable for the attorney's statements. Vicariously liability. You know, he works for you, you're responsible for him. And that's vicarious liability. He did it, but you're responsible. He's also responsible, incidentally, but of course, Johnny Depp is the pocket. Depp filed a motion for summary judgment on the count. The trial court denied. The case was tried. At the end of Ms. Heard's case, Depp made a motion to strike, which was denied, and Depp renewed such motion. So we're just proving that we have preserved the issue for appeal, which is always a good thing. Of course, the jury returned a verdict, and which was overwhelmingly in favor of Depp. At least in terms of the financial numbers, yes. The jury found Depp liable for $10 million and $5 million in punitives, which of course was reduced by law. On the counterclaim, the jury found Depp in favor on 2 of 3 Waldman statements. That's right. 2 of the 3, they said no liability. Only 1 of the 3 did they say liability. So there's only one statement at issue. The court entered judgment and we timely appealed. All right, we have preserved the issue. There's only one statement at issue, right? Because she only won on one statement. Depp won on 3 statements. She won on 1 statement. So we have 1 statement, 1 issue. Great. And then, of course, here in a footnote, we note that there is a punitive damages cap of $350,000 for a total damage award of $10.35 million. Introduction. The jury's emphatic favorable verdict on all 3 defamation statements alleged in the complaint fully vindicated Depp and restored his reputation. Well, kind of by necessity to some degree. That's kind of what it's supposed to do. It's supposed to make you whole, so I guess they feel whole. Indeed, Mr. Depp prevailed in trial court on virtually all material issues, and the verdict of the jury and judgment of the trial court represents an intelligent and well-reasoned decision on the merits. The jury is best jury, which could potentially cut against you on B and C, but we'll see how we get there. And should largely, though not entirely, be affirmed. Well, I can think of one reason they shouldn't be affirmed, right? However, the trial court was confronted with a number of novel and complex legal and factual issues, and although the trial court decided the vast majority of those issues sensibly and correctly, a few rulings were erroneous. Even the best of us, right? Even the best of us. Different judges make different mistakes. Would I have made this mistake? Probably not. Would I have made other mistakes? Probably. You know, there's a bit of humanity in the whole exercise. Mr. Depp does not appeal the verdict on his claims, which, you know, would be a little bit odd. Why would you appeal the verdict that found for you? Well, I suppose you could. I didn't like that the jury ruled for me. They should have ruled the other way. Yeah. Nor does he appeal the verdict in favor of the 2 or 3 statements. Again, that'd be a really weird appeal brief. I'd like to appeal the jury finding in my favor. What? Right? That'd be a weird appeal brief. His appeal relates solely to the Waldman statement on which they prevailed in a statement in Daily Mail. I mean, actually, I could theoretically imagine some reason you'd want to appeal some finding because of some other reason, but whatever that would be, it's not here. So is there some situation in which you might want to appeal a judgment in your favor? Maybe. Yeah, I'm sure we can think of something if we think really, really hard. Law is fun sometimes, right? Sometimes weird things happen. Ms. Heard's claims were fatally flawed, and the trial court should have granted the motion for summary judgment and the motion to strike evidence for 3 reasons. Okay. First, Depp cannot be held liable for Waldman statements as a matter of law. This is my understanding of Virginia law, which, you know, I'm a Virginia lawyer, so yeah, and hopefully soon to be a Texas lawyer. Are we right? Anyways, Ms. Heard sought to hold Mr. Depp liable for an April 27th Waldman statement on pure theory of vicarious liability, right? It's not that Depp himself did something. It's his agent, namely his employee, did something. Contending that Mr. Depp was liable merely because Waldman had been retained as his attorney and therefore was his agent. That was the legal theory. But as a matter of law, Waldman is an independent contractor whose alleged tortious conduct is not automatically attributable. That's my understanding of the law too. Indeed, a wealth of authority supports limiting a client's liability for alleged tortious conduct by an attorney, and the court should impose that same limit here. Yeah. Second, because Ms. Heard proceeded against Depp at trial on purely vicarious theory of liability, she's required to present evidence that Waldman committed each evidence of the tort, including added with actual malice. Yes, that would be right. Yes. No evidence of Waldman's malice was present, so a judgment against cannot be sustained. No evidence? Third, the Waldman statement view in context is a non-actionable statement of opinion insufficient to support a claim. All right, we'll give that a shot. In addition to erroneously denying Depp's motion for summary judgment and motion to strike, the trial court also erred in excluding from evidence the complete Daily Mail articles containing the Waldman statements. That's quite possible. They didn't have enough context, and defamation should be understood in context, so that might be a fatal flaw. That's fair. And refusing to give jury instructions as independent contractor. That might also be a fatal flaw. That's also potentially fair. All right, let's give this a shot. Assignment of error. 1. The trial court erred in denying Depp's motion for summary judgment as to Heard's counterclaim and Depp's motion to strike. Waldman is an independent contractor and Depp is not liable as a matter of law. Heard failed to present any clear and convincing evidence. Waldman's statements are non-actionable. Preserved. This is to show that they are preserved, right? So we're going to go through the history to show we preserved the issue. I'll skip that because we don't need to go through the history. I'm quite sure they preserved the issue. And similarly for that, we can skip that part. All right, statement of facts, the Waldman statements. In connection with her counterclaim, Ms. Heard contended at trial that Mr. Waldman, acting as Depp's agent, defamed her in 3 statements in the United Kingdom. The first statement was quoted in a Daily Mail article dated April the 8th and stated that Ms. Heard had, quote, faked sexual violence allegations, unquote, and promoted, quote, sexual violence hoax facts, unquote. The article also contained a general discussion of the dispute and litigation between Depp and Heard, and quotes from attorneys adverse to Depp. The jury did not find the statement to be defamatory. The second statement was quoted in June the 24th, 2020 Daily Mail, and stated that Mrs. Heard's allegations were, quote, hoax, unquote. The article included a quote from Ms. Heard's attorney that, quote, we believe Amber and we believe in Amber, unquote. Well, that's obviously a mistake. And summary of both Mr. Depp and Ms. Heard's sides of the dispute. The jury didn't find this to be actionable. AJ, you're not understanding why he's doing that and what he gets out of it? $2 million and $2 million would be the answers to your questions. The April 27th Waldman statement, the sole statement on which the jury found in Ms. Heard's statement, is contained in Daily Mail article dated April the 27th of 2020, with a highline, exclusive. I need to report an assault. Listen to the 911 call made by the Nines. Johnny Depp and Amber Heard had blowout fight that ended their toxic 18-month marriage, but both claim the tape backs up their version of events. The April 27th article describes a recording of a phone call to police on the night of May the 21st, 2016, a date. We are not reading Heard's appeal. We're reading Depp's appeal. Heard has given a notice of intent to appeal. As far as I understand, the brief has not yet been filed. Anyways, carrying on. The April 27th article describes a recording of a phone call to the police on the night of May the 21st, 2016, a date on which Ms. Heard alleged Mr. Depp threw a phone at her and roughed up their apartments at Eastern Columbia building. The April 27th article comments that Heard's attorney says phone records and police department logs vindicate Heard's accounts of their final shocking episode of domestic violence before she endured before filing the divorce, whereas Depp's legal team says the recording does the precise opposite. However, by raising discrepancies in the various accounts, Heard and allies have given the notorious dust-up. It details Heard's various allegations about abuse she claims to have suffered on May the 21st, 2016. Noting that domestic violence case ultimately fizzled when 2 LAPD officers who responded to the 8:27 p.m. call, Melissa Sanez and Tyler Hayden, said they never found any evidence of crime. The April 27th article further states, Depp's lawyers, Adam Waldman, and said the various discrepancies proved that nothing Heard and her friends said about the events of May 21st, 2016 could be considered credible. It sets out Waldman's purportedly defamatory statement as thus, quote, quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouse, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their story straight under the direction of a lawyer and publicist, and then placed a second call to 911 on quote. So that was the statement that was allegedly defamatory. The April 27th article also includes quotes from Waldman that Heard did not include in her defamation claim. But this even, well, okay. But this even this didn't have the desired effect because 2 domestic abuse-trained LAPD police would rather provide a pair of sworn depositions saying they saw no head of a crime. These lies about who made the calls and when are just the tip of the iceberg, as Ames will show in court. Finally, it presents a contrary view, quoting Heard's attorneys at the time. Heard's legal team rejected those allegations as fantasies. Depp's representations about the 911 call on the night of May the 21st, 2016 are false, and Depp and his lawyer should know better. Well, I think they're substantially true, which I didn't see as a raised error, but I think they're substantially true and not actionable for that reason. Maybe that's a subheading somewhere. We'll see, but I didn't think any discrepancy between what was said and what was true was enough to be a valid basis, but maybe they'll raise that issue. All right. Ms. Heard presented no evidence at trial that Depp was personally involved in directing or making any three statements. That would be another way to get to him, that he directed it. That would do it. But no evidence of that, apparently. And I don't really remember any evidence of that. This is pure vicarious liability. That would be another way to get to Depp. Depp commanded it. That would do the trick. But that wasn't the argument. Pure vicarious liability. He's responsible solely because Waldman is the agent. Not necessarily that he directed it, but responding at superior. So, yeah. Indeed, Mr. Depp testified they'd never even seen the statements prior to filing of the counterclaim. Waldman has a professional license, is the owning and managing member of his own law firm, and provides legal services. Waldman was retained by Depp in October 2016 and still represented Depp at the time of the trial testimony, but Depp is not his only client. Waldman's relationship with Depp is one solely of attorney-client. Fair. And has represented Depp in various litigation matters, including his litigation against Heard. Fair. Yes, it seems to be true. He represented Depp on a number of different matters over a couple of years. And although there are a number of different matters, that by itself doesn't make you an employee. It just maybe makes you an independent contractor each and every time. Waldman testified that while he believed he had some knowledge of the conduct of Depp and Heard, he never personally witnessed any actions between them prior to retention, which was after their separation. So he's not an eyewitness, which would go a lot to his knowledge, by the way, or lack thereof. So that would go to his ability to have actual knowledge. How would he actually know? Because he actually was there, but he wasn't actually there, so he can't have actual knowledge. Unless, of course, he knows that he's lying and just making it up, which, there's no testimony about that either. Waldman testified that he made each of the statements. Heard did not present any evidence on whether or why Waldman believed the statements. In response to a more general inquiry about Heard's allegations, Waldman testified at length on why he believed Heard's allegations against Depp were false, describing physical evidence and identifying multiple witnesses whose testimony he believed contradicted her allegations. Waldman also testified he had filed a claim with the Los Angeles Police Department against Heard for perjury due to her claims, and that he presented them with information that established perjury. Okay, fair enough. So we're going to why he has an opinion based on these things. Okay, so that forms the basis potentially of his opinion. All right, that's a little bit of summary of how we got here. Let's get to the law. The trial court erred in denying Depp's motion for summary judgment and motion to strike. In reviewing a ruling on a motion for summary judgment or motion to strike, the court normally considers the relevant portion of the record in the light most favorable to the non-moving party and draws reasonable inferences in favor of the non-moving party. Correct. The lower court has spoken. The appeal court is going to interpret everything in light of the verdict below. They're looking for a reason. They're looking for a reason to say yes, not for a reason to say no. If they find a reason to say yes, they're kind of done. So yeah, they're looking for a reason to say yes. So you have to show them there's no reason to say yes. That's kind of where you're at in appeal. However, an appellate court in Virginia on the issue of punitive damages, or where actual malice must be proven, must independently decide whether the evidence in the record on appeal is sufficient to support actual malice by clear and convincing proof. Yeah, but that's kind of a legal threshold question, and the trial court already kind of spoke to that, and yeah. In addition, questions of the law are subject to de novo. They always are. Whether an alleged defamatory statement is actionable is a matter of law. That's true. That's absolutely true. Whether it is actionable in the first instance is a matter of pure law. That's true. Under most circumstances where a person is employee or independent contractor is generally a question of fact for the jury, but whereas here the evidence admits of only one conclusion, the question is a matter of law, which is kind of always true, right? Things are questions of fact unless they're not. If there's no dispute or there's not enough evidence to raise the dispute or whatever, right? If there's only one possible decision the jury could reach, right? Juries are allowed a lot of latitude, but not infinite latitude. So if there's only one conclusion to reach and they reach the opposite conclusion, that's legal defect. So true, fair enough. All right, let's go through the law. Heard presented no evidence at trial that Depp was personally involved in making or directing the statements. Correct. Instead, she chose to pursue pure vicarious liability, that he was liable simply because he was the attorney. Correct. Respondeat superior. It's not that I directed it. It's not that I commanded it. It's not that I influenced. I'm responsible solely because I am the employer. Okay. Ms. Heard's proposed jury instructions on her counterclaim, which the trial court adopted and gave the jury, were based solely on vicarious liability. It did not require any finding of conduct by Depp. Yeah. So we have to find Waldman did the thing. We have to find two things. Waldman did the thing, and that he's an employee of Depp. And if so, then Depp is responsible. Fine. The claim, therefore, falls on the threshold issue. As a matter of law, Depp cannot be liable for the intentional tort based solely on statements made by his attorney on pure agency. In the context of vicarious liability, Virginia has long recognized the distinction between servants and independent contractors, which is pretty typical in most states, incidentally, and follows the well-established rule that the principal, that's the person who's the employer, is generally not responsible for the tortious conduct of an independent contractor. Recognizing that in Virginia, the doctrine of respondeat superior imposes tort liability on an employer for negligent act of employees, which is their servants, but not for independent contractors. Again, this is fairly typical. Your mileage may vary in some states, but that doesn't seem to be more or less the standard rule. And declining to adopt an exception for this rule of the independent contractor who is ostensibly or an apparent agent, which is another way to potentially get there. Like maybe they're not really an agent, but they're an apparent agent, which I could, could create problems. But if they're an independent contractor, then it doesn't matter in Virginia. So again, your mileage may vary depending where you are, but we're in Virginia, so fine. Chris Kiska is a member for 3 months, and Brent is a brand new member. Welcome to the Uncivilians, Brent. I appreciate you being here. It's very nice. The theory on which the master is held liable for a servant is based on the right of the master, actual or potential, to control conduct and see to it negligent acts which cause injury do not occur. If the relationship between them does not give the employer that power, then he should not be held liable for an occurrence over which he has no control. In ascertaining whether a person is an independent contractor, courts consider 4 factors: selection and engagement, payment of compensation, power of dismissal, and power to control the work of the individual. The fourth factor, the power to control, is determinative. That can't possibly be true, because if it really were true, I know they're quoting the case law, but that can't be true. If the fourth factor was really determinative, then why have any of the other factors? So that seems like that seems like the law, it can't mean that, because that wouldn't make any sense. All right. Mr. Depp has not been able to identify any Virginia Supreme Court authority squarely considering the specific issues of whether an attorney retained in connection with litigation is an independent contractor, and whether the principle limiting liability for conduct of an independent contractor applies in the principal agent context, specifically with respect to the attorney-client relationship. So, okay, maybe nothing specific in this domain, all right. Notably, the Virginia Supreme Court has sided with apparent authority, the restatements approach, which limits liability of a principal for actions of a non-servant agent. Agent Ruski becomes a new member. Thank you very much for hitting that join button and becoming a new uncivilian. Okay. However, although the jurisdictions are not uniform, the majority rule and the rule that should be adopted by this court is that an attorney retained by a client for litigation, though undoubtedly an agent of the client in the litigation, nonetheless stands in the capacity of a non-servant agent, independent contractor, and therefore the client is generally not vicariously liable for the lawyer's misconduct, absent exceptions to general rule that are not present here. Yeah, I think I tend to agree. Like the exceptions to the general rule obviously would be like corporate counsel would be your biggest exception, right? Then the lawyer works for the corporation as an employee in the corporation. So that'd probably be your biggest single exception, I would imagine. But generally speaking, I tend to agree. Like if you hire a lawyer, they're not your employee. And if you go through like the sort of multi-factor test that we would use, for example, for tax purposes, like if we're thinking about this from the position of federal benefits, for example, if we're thinking about this from whether they should be taxed as a employee or we're thinking about this for the purposes of unemployment insurance and stuff like that, then different states have different rules. And we went through this, for example, in California when we were discussing this with Uber, when they were being sued way back when. But most states have a multi-factor test, and it's a lot of factors normally. Normally it's like 8 factors or 13 factors or something. It's a lot of factors on whether someone's an independent contractor or an employee. But typical factors are such things such as, do you get to set your own hours? Whose tools are you using, your own or theirs? You know, do you get to choose what to wear? Do you get to choose particular assignments, when to do them? Do you get to choose the method of executing those assignments? You know, do you get the ability to work for other companies? That's a good one. What else is there? You know, is this like a trade for which the business that is hiring you is not in the business of that trade? That's a factor, right? And other factors beside. Right? So this is like the normal multi-factor inquiry that we sort of go through in this sort of analysis. Again, depending on your jurisdiction, different states have different rules, but still. But yeah, I mean, okay. So if we're going to kind of go to those factors, attorneys seem like independent agents. You know, they get to set their own hours. They use their own tools. They're using their own library, not yours. You know, they get to control when they do things, how they do things, so forth and so on. So probably not so much with employees again, except in the context of corporate counsel where, you know, okay. Or I guess if they're working for a law firm, then they'd be employees of the law firm to the extent, yeah, okay, well, you know what I mean. All that good stuff. Excuse me. Leanla Borsa says, sorry if this was already answered. If she's trying to claim the court doesn't have jurisdiction over her because she doesn't live in the US anymore, then how's she able to file appeal? That case is a completely different case. The case you're referring to, where they're saying that the court doesn't have jurisdiction over her, is a federal case dealing with her insurance companies. So this case is a state level case in Virginia. The reason, incidentally, they're saying that they don't have jurisdiction is because if she doesn't have a state of residence, then she, under the applicable federal law, diversity jurisdiction would be defeated. Because we're in federal court, not state court in that case, and so she's trying to defeat diversity jurisdiction, which would send it back to state level authority. But she was a resident at the time the lawsuit was filed, so I think she's going to have problems. But the thing, we don't need her to be a resident of anywhere in order to sue her in Virginia, because the underlying basis is that the tort itself was committed in Virginia. Right? It would be the same thing as it would be comparable to if I got into an automobile accident in Virginia, right? My legal residency is kind of irrelevant. The tort occurred in Virginia. So the action itself gives the basis for the lawsuit. And so similar here. And in the case that you're referring to, it's a contractual matter, not a tort. So anyways, yeah, that's in a federal case. It's in a completely different case. Amber Heard's involved in several different cases at once. Okay, where were we? Is that subject matter jurisdiction? Yeah, technically. In the federal case, yeah, technically. I mean, if she's not a diverse person, then yeah, the federal courts don't have jurisdiction because they only have federal question jurisdiction and diversity jurisdiction. So if she's not diverse, then I guess technically that is subject matter jurisdiction. Yeah. So hey, there you go. Pressing on. Anyways, it's a personal jurisdiction issue that then undercuts the federal statute for the basis of the lawsuit. So also speaks a little bit to subject matter. So a little bit of column A, a little bit of column B on that one. All right. Anyways, although other jurisdictions are not uniform, we should say that they're a contractor here. Although the authorities are not unanimous, most other jurisdictions that consider this issue have concluded that attorneys retained in litigation act as independent contractors, and those jurisdictions have accordingly imposed limits on client liability for tortious acts by their attorneys. And then we got some quotes, one from the District of DC. The weight of authority provides that a client generally is not vicariously liable for an attorney's torts absent evidence that the client directed, controlled, authorized, or ratified. Yeah, but that's not what we're arguing here. From the Eastern District of Virginia Federal Court, a law firm attorney working for a client is nonetheless an independent contractor and not an employee of the client corporation. From California, independent counsel retained to conduct litigation in the courts acted capacity of independent contractors. From Georgia, under traditional master-servant law, the attorney was an independent contractor. We think the unique attorney-client relationship should not be analyzed merely with reference to ordinary agency law. A general retention of an attorney to do all things necessary to pursue a claim or defense should, in legal contemplation, mean the attorney has the authority to do all things legal and proper, not otherwise. We will not presume direction or authority or permission to conduct a tortious or illegal act inheres in the usual attorney-client relationship. That's probably a pretty good rule, right? I mean, if you're hiring an attorney, you're probably not hiring them to commit a tort, unless you're hiring Saul Goodman. So we could come up with a Saul Goodman exception, but, you know, okay. In Illinois, when as here an attorney acts pursuant to the exercise of independent professional judgment, he or she acts presumptively as an independent contractor whose intentional misconduct may generally not be imputed to the client. Ophelia, Leanna Borsa says, thank you for answering it that way. I didn't know if one affected the other in any way, so thanks, you're welcome. And Ophelia the Fair gives $1.99 to give me a little heart. That's very, very kind. Thank you. Let's see, where were we? In New Jersey, there's a vast difference between an employee agent and a non-employee agent. The non-employee agent is generally nothing but an independent contractor. Attorneys generally are not subject to their control, actual direction. It is amazing to me that Virginia does not have anything specifically on the point in the attorney-client relationship about independent contractor. That's amazing to me. I'm sure they looked, but I mean, it kind of goes against this ethos that Virginia has. They have this little this erudite authority that they're better than all the other children. Little fact that horrifies most people, that when they fact that horrifies the attorneys when they learn it, is that in order to take the bar in Virginia, you have to do it in suit and tie. They make you dress up for court in order to take the bar. That was not a Texas thing. They didn't care what I wore in Texas. And in Virginia, they care. Coat and tie, baby. And rubber-soled shoes. And I think it's all because, well, we're Virginia. We've had law for 400 years. We're best day, we had one of the original colonies over here. We go way back, okay. And in 400 years, they don't have any cases that speak to the specific issue of attorney-client relationship liability in vicarious liability. It's amazing. Okay, I guess there's still new issues even in 400 years later. Okay, well, that's fun. In New York, treating law firm retained by insurance company as an independent contractor. In North Carolina, concluding that a law firm was an independent contractor whose negligence, if any, is not imputed to the insurance company that retained it. In Texas, woot, the mere fact that an agency relationship existed between the client appellees and the attorney appellee does not mean the client appellees would automatically be liable for any tortious conduct. Unless the client is implicated in some way other than by merely being represented, the client cannot be liable for the attorney's conduct. That makes more sense, yeah. So we've got a bunch of authority from a bunch of different states. And we're like, hey, Virginia, how about you like do that? That sounds pretty good. There are other sound reasons why multiple jurisdictions have concluded vicarious liability should have limited application in the context of attorney-client relationship. Lawyers, as legal professionals, typically are not subject to their client's control with respect to the manner in which they provide services. Very, very true. Client sets the goal, somewhat broadly. Lawyer executes, sometimes in consultation, sometimes not. You know, it depends on your lawyer and your relationship and their style, but yeah. If clients cannot control the details of their attorney work, it makes little sense that clients should nonetheless be held accountable for their actions. Fair. Attorneys generally are not subject to their clients' actual control or direction. Instead, most clients have an attorney because they're unfamiliar with the law and want an attorney to guide them through the intricacies. As professionals, attorneys are deemed responsible for their own acts, and in this case, most clients have legal recourse against their attorneys and law firm. Yeah, this is kind of true, generally speaking, of like most professional fields. You know, for the same reason, it's one of those factors in that multi-factor test we talked about earlier. You know, you hire a doctor, you're usually not controlling them. You know, because what do you know? You hire an attorney, you're usually not controlling them because what do you know? Kind of when you're hiring a professional of anything, you're kind of doing it because, well, their skill supersedes yours. So like, fix my car, fix my plumbing, fix my heart, fix my deed, and the easement that's running across of it. Also, it's shared by another guy, and also someone else has been living on my land for 21 years. And I'm like, okay, wait, what's going on? Anyway, sorry, I got into a black acre discussion there for a second. Yeah, so not so much typically, because that would be kind of dumb. Great. In every American jurisdiction, including Virginia, and then of course in Texas, I get to add to the black acre nightmare, because in addition to all the things I just mentioned, hey, did you know there's oil under this land? Oh my God. And it spans multiple plots. Help me. Help me. What are the adverse possession rules, unlike part of a parcel that also contains oil? Moving on. Moving on. In every jurisdiction, including Virginia, lawyers required to exercise independent professional judgment and is subject to independent professional and ethical obligations. A lawyer shall abide by a client's decisions concerning the objectives of representation and shall consult with the client as to means by which they are to be pursued. Now, mind you, it says consult. Shall abide by the client's decision and shall consult are definitely not the same thing. So we're required to ask. We're not required to do anything you say, though. But we have to ask you and then ignore you. In representing the client, a lawyer shall exercise independent professional judgment and render candid advice. Good ideas. A lawyer is prohibited from advancing frivolous arguments. That too. And a lawyer has a duty of candor to the court and is permitted to refuse to present evidence on the behalf of a client the lawyer believes is false. Yeah, you know, lawyers should not be compelled to commit frauds upon the court. That seems like a good rule. A lawyer in sum is required to exercise professional expertise beyond that of the typical client. A lawyer shall provide competent representation. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. Good place to start. There are accordingly substantial limitations on a client's ability to control the activities of a lawyer. In any case, the typical client, who generally lacks legal expertise, cannot monitor the conduct of a lawyer for wrongful activity. As the client's agent, the lawyer's conduct may be binding on the client with respect to positions taken in litigation or the business transaction. So yes, your lawyer can bind you, the client, because they're your representative, so yeah. But to hold the client liable for the attorney goes too far. So yes, the attorney might be able to bind you, or the attorney can bind you, but you can't bind the attorney necessarily because, yeah. Here, evidence established that Waldman was retained by Depp to act as attorney and acted in the capacity in several litigation matters, including the initial stages of this litigation. Other facts that undermine Waldman's role as an independent contractor only are that he is the managing partner of his law firm, or underline, not undermine. I was very confused there for a second. Let me reread that line. Other facts that underline Waldman's role as an independent contractor only are that he is a managing partner. I don't like the way this sentence is phrased. Only are that he is the managing partner of his own firm, has clients other than Depp, and offers legal services to other clients. I tend to agree. Ms. Heard presents no evidence that Depp was personally involved in directing or making the statements. That wasn't the theory of the case. In fact, the uncontroverted evidence was that Depp never saw them. Accordingly, the premises of the counterclaim is that Depp is liable to statements for no other reason than respondeat superior. No one appears to dispute that Waldman did not act in any capacity for Depp other than attorney. As Depp's attorney, Waldman should be considered an independent contractor whose tortious interference, if any, cannot be imputed. What, if any? If cannot be imputed to Depp without some proof of direction or control. Yeah, well, putting aside the continuing PTSD of the if any. Yeah, that's right. The uncontroverted evidence established that Waldman was only independent contractor for Depp. As a matter of law, therefore, Heard cannot hold Depp liable for any of the statements the trial court erred. Yeah, okay, so I agree with the theory of the case. It amazes me that Virginia apparently has no law on point. This is, I mean, now at least the trial judge's decision is much more understandable. I was under the impression there was some case law on point. Apparently not. Okay, so we have to make it up. No problem. That's what the Court of Appeals is for. So the trial court probably did the right thing in balance, because if they get reversed, then, you know, they can just strike it out. If they made the decision the other way and they got reversed, then we'd have to redo the trial, and that would be really good for me as a streamer, but probably not so good for the court. So in the face of any case law, they probably did the right thing by having the thing and then let the Court of Appeals strike it down so we didn't have to redo everything. So, I mean, okay, fine. I understand Judge A's decision's a lot better now. She's trying to make the decision that is in the judicial economy of the court's consideration. Probably doesn't want to see any of these people ever again. So, makes sense. All right, Ms. Heard presented no evidence of Waldman's actual malice. All right, so let's see how this goes, because this will be a little bit interesting. Even if the court were to conclude that Depp could be liable, the trial court nevertheless erred in denying the motion for summary judgment and motion to strike because Heard failed to present evidence to establish a required element. Specifically, Heard failed to present evidence that Waldman acted with actual malice. Okay. As noted above, Heard chose to pursue her theory of vicarious liability against Depp. She did not ask to find Depp was directly involved. Vicarious liability is liability for the tort of another. Vicarious claim therefore cannot proceed against the employer or principal absent showing they committed the tort. Vicarious liability is liability of a tort of another person. It necessarily follows a claimant cannot make out vicarious liability claim against the employer without first proving the employee committed the tort within the scope of employment. Yeah. Because a principal cannot be vicariously liable for his agent tort unless the agent committed all the elements, Depp cannot be liable unless Heard carried out her burden of proving all the elements. With respect to the requisite intent, a plaintiff who's a public figure, such as Heard, must prove false and defamatory statements with actual malice. That is, subjective knowledge it was false or reckless disregard. All right. In order to establish actual malice, a plaintiff must demonstrate by clear and convincing evidence, which incidentally the jury said they did, they checked the box, that defendant realized the statement was false or had subjectively entertained serious doubts. Importantly, actual malice is a subjective standard that analyzes actual beliefs of the person publishing the defamatory statement. Actual malice is not measured by whether a reasonably prudent man would have published or would have investigated. That's true. It is not a reasonable man test. That's true. Rather, there must be some evidence, although you can use the reasonable man test to get to at least partly whether or not they subjectively believe it or not, right? If it's too incredible, maybe they didn't really believe it. So the reasonable man test isn't directly on point, although it might be informative. Things get fun. Anyways, rather, there must be sufficient evidence to permit the conclusion defendant, in fact, entered serious doubts as to truth of publication. The evidence must establish defendant had a high degree of the awareness of probable falsity. That's basically essentially correct. Thus, for instance, a mere failure to reasonably investigate one's words is not enough to establish actual malice. True. Because that would be like negligence, not recklessness. Because it does not establish subjective knowledge of falsity. Indeed, in the context of actual malice, a duty to investigate the accuracy of one's statements does not arise until the publisher has a high degree of subjective awareness of their probable falsity. Yeah, that's basically the difference between negligence and recklessness in so many words, right? It's not enough that there be some indications of falsity. It has to be enough that there's like so many that I'm just, devil may care in the face of, without investigating further. So yeah, that's basically essentially correct. Thus, to succeed on the defamation claim against Depp, Heard was required to establish by clear and convincing evidence that when Waldman made the statements, he either knew they were false or subjectively had a high degree of falsity. Clear and convincing evidence is that measure or degree of proof which the mind of the trier of fact provides a firm belief for conviction as the allegations sought. On review, appellate courts must exercise independent judgment and determine whether the record establishes actual malice with convincing clarity. Yeah, but this is partially a thing of fact. So again, the Court of Appeals is looking for a reason to say yes. They're looking for a reason to agree with the jury. They're not looking for a reason to disagree with the jury. Appellate courts interpret things in the light of what's already happened. So the jury has already said, well, we found clear and convincing evidence. So basically what you have to do now, if you're Johnny Depp, you have to show them that that was completely unreasonable. That there wasn't enough evidence. It was completely unreasonable. That's hard. It's possible, but it's hard. So this is a legal standard, but it's hard. Okay, then they say Miss Heard presented no evidence, much less clear and convincing evidence. Although I'll take note here for what it's worth, that the evidence doesn't, of course, have to be direct. It can be inferred, right? The jury is entitled to find all the facts and all reasonable inferences therefrom. So, Miss Heard presented no evidence, much less clear and convincing evidence, that Waldman made the statements with actual malice. Indeed, with respect to the statement, Heard presented no evidence regarding Waldman believed the statements to be true or false. You don't necessarily need any statement from Waldman. If you can infer from the facts to the degree they're available. You can say that Waldman is, aware of things because he's a smart guy and following things and stuff. So, but of course it's a judgment call, right? All the evidence adduced at trial pertaining to Waldman's state of mind when he made the statements show that Waldman believed the statements to be true. Well, that's what he said. The jury could, of course, disbelieve him. Juries are the finder of fact. So Waldman might say it's true, but the jury says, no, you're lying. I mean, they could. Waldman testified at length, for example, about why he believed Heard's allegations of abuse were false, citing testimony from multiple witnesses that contradicted the accounts of events, including discrepancies. That would be reason to think that Waldman's telling the truth. In fact, Waldman testified he filed a claim with the LAPD against Heard for perjury and presented them with evidence. He believed established that. Since Heard presented no evidence that would permit the jury to find by clear and convincing evidence, he subjectively knew they were false or provably false. Yeah. The trial judge erred in denying. Waldman's statements must be reversed. This is a bit weak. It's possible. It's possible. And I don't blame them for trying. It's, you know, it's just so, I don't know. I just feels, I don't know. It feels a little underdeveloped to me. It feels a little heavy on theory and light on fact. It feels a little conclusory in my mind. I wish I had more specific things, like maybe some direct quotes or something from Waldman's testimony, or some, like, you know, a little bit of interlude there. It's just a little underdeveloped for my taste, personally. And it's not to say that he's going to lose on this. He could absolutely win. He could absolutely win. But I don't know. It's a little heavy on theory. A little lighter on application than I would like. But, you know, that's okay. All right, let's see what we got. See how C is doing. If the court believed Depp could be liable for the statements, Heard's counterclaim for defamation is still fundamentally defective because, read in context, the statement is not actionable. The trial court erred in not granting Depp's motion for summary judgment. Pure expression of opinion, not amounting to fighting words, cannot form the basis of defamation. The First Amendment to the federal Constitution and Virginia's Constitution protect the right of the people to teach, preach, write, or speak any opinion, however ill-founded, without limitation, with action by libel or slander. Conversely, of course, there's no constitutional value in false statements of fact. Excuse me. Thus, in an action for defamation, a court must resolve as a threshold matter whether the alleged statement is one of fact or opinion. A statement of fact is one in which a provably false factual connotation, which can be interpreted as stating facts. However, even a provably false statement is not actionable if it's plain that the speaker is expressing a subjective view, interpretation of theory, conjecture, or surmise, rather than being in the possession of objectively verifiable facts. Yeah, but it's Waldman saying it, and he might be in the possession of facts. That's a problem, right? Waldman might know things because he's in a position to know things. See, this is the difference between him saying this thing and me saying this thing, right? Or you saying this thing, right? So the same thing, the same exact words can be defamation or not, depending on who's saying it. Because, of course, for any number of reasons, like, for example, their internal mental states can be different. Or in Waldman's case, right, if I said literally the same exact words, there's no way to infer, there would be no reason to infer that I have special knowledge, right? I'm not on Johnny Depp. I'm not a friend of Johnny Depp. I, you know, sadly was not invited to the latest concert with Johnny Depp. I haven't been brought on stage and been told by Johnny Depp how much he loves me, much to my disappointment. Johnny Depp, please return my calls. But, you know, I'm not an attorney for him. So there's no reason to think that I personally have some sort of special knowledge. But that isn't true for Waldman, because Waldman has a more close relationship with Johnny Depp. And so, yeah, there's a bit of a problem there, potentially. Ophelia, whether or not people lie or not is a question of fact for the jury. I'll just politely remind you. Whether or not someone is lying or not is a question of fact for the jury. Are the people lying? I don't know. Ask the jury. And how do we do it? How do we deal with it as a court of appeals? Right? How do we deal with it as a court of appeals? Well, that answer is easy, right? We're going to infer every colorable, well, colorable is too strong. We're going to infer every reasonable, that's better. We're going to infer every reasonable fact and every reasonable inference the jury could find. Because we're looking for reasons to say yes, not reasons to say no. So did they tell the truth? I don't know. Is the answer to that, if the answer to that question is yes, it would further cement the jury's conclusion, then the answer is yes, they told the truth. The jury must have found they told the truth because they said, hey, they agreed with it. It must be true. So, you know, that's what juries do. At least in part, right? If Waldman paid taxes using a 1099, does that prove he's an independent contractor? No, not necessarily. Because as I said, and I tried to speak to this issue, right, a little bit, like whether you're an independent contractor or an employee for one purpose doesn't necessarily speak to whether you're an employee or independent contractor for another purpose. It gets really, really complicated. So does a 1099 show he's an independent contractor? A 1099 shows he's an independent contractor for the purpose of federal tax filings. Okay, importantly, whether assessing an individual words or fact or opinion, a court must examine them in context with the aim being to interpret them as other people would understand them and according to the sense in which they appear to have been used in totality. Thus, considering whether a statement's audience would understand it as a statement of fact or opinion, courts consider such factors as the form in which the alleged defamatory statements were uttered and whether an audience familiar with the form would expect to hear an opinion. Citing the Ninth Circuit, if a statement is made in a form in which a reader would likely to recognize the critique represents the highly subjective opinion of the author and relates to inherently ambiguous subject matter about which reasonable minds could draw different conclusions, the general context in which the statements were made negates the impression that they imply a false assertion of fact. Well, that's helpful authority from the Ninth Circuit, at least. Courts also consider the degree to which the statement's audience are familiar with underlying facts and therefore able to assess defamatory statements. Again, the problem here is that Waldman, it would be reasonable for the audience to think that Waldman might be in possession of hidden facts because of Waldman's position. And so those facts could be potentially implied. That's a bit of a problem, potentially. According to the Third Circuit, concluding statements were opinion when made to reporters who are familiar with long-running dispute among the parties and knowledgeable about underlying facts and therefore understood defendant was presenting his own opinion. Okay. In addition, courts consider whether the statements were made in the context of a debate or controversy because statements made in the heated debate are more likely to be understood by their audience. This isn't really that though, but okay. Courts also consider the identity of the speaker. Yes, that's exactly what I've been talking about for the last couple of minutes. And whether the speaker's biases are known and disclosed. The most unsophisticated recipient of a claim made by one's competitor against another could only be regarded as a statement of opinion grounded upon the statement's objective, obvious bias. I'm not sure it's necessarily applicable here, but okay. Further, courts can consider whether the speaker's claims to have personal knowledge or is merely drawing inferences about events he does not claim to have witnessed. His ability to witness them or not doesn't necessarily speak to whether he has special knowledge or not, because again, he's the attorney in the case and presumably has access to all kinds of information you and I have never even heard about. Right? What was presented at trial is a small subset of the total amount of information. You all understand this, right? The amount of information that was provided in discovery far exceeds the amount of information that came out at trial for every possible reason. Time, relevance, confusion of facts, strategy, tactics, right? So does Waldman know things you don't know? Yeah. Does he know things you've never heard of? Yeah. So if Waldman makes a statement, could it be understood that he's communicating that he has secret knowledge? Yeah. So that's a bit of a problem. That's a bit of a problem. Yeah. Patty C says if 2 of the 3 statements were eliminated by demur, they weren't. They were presented to the jury. 3 statements were presented to the jury. They weren't eliminated by demur. Is it logical this 2 should have been eliminated? No. No, all 3 statements stand on their own. This statement had more information. It's completely logically consistent to find one and not the other, because this statement had more stuff in it. Now, personally, I don't think that stuff matters, but it doesn't seem like we're arguing that, which seems like a missed opportunity, but maybe we missed it because of word count issues and page count, because we're on a page count. But to me, there's a pretty decent argument to be had here that doesn't seem to be being had, that there's not enough daylight between the statement and the pleaded truth for it to matter. But we don't seem to be making that argument for some reason. Hi, Generous. Thank you for the orange hearts. I appreciate them. I appreciate all you. I appreciate the 436 of you who are currently in chat. I like you all. You are the best chat. And I appreciate your questions because they allow me to try to clarify things and provide context and things. And I really, really appreciate it all. You guys are great. All right, let's see what we got. Let's see. Okay. Citing the Fourth Circuit, that's where we're at. No liability when there's no claim to firsthand knowledge of facts, and the context and tenor of the article thus suggests it was reflective of the writer's subjective and speculative supposition. The statement is the statement. I'll read it again. What the hell? The statement is the following statement. Okay, so this is the defamatory statement. All right, so this is good. This is a good opportunity, right? So let's try to move back in our minds, right? And forget some of the things that perhaps we know. We have to move back in time, right? We have to move back in time. It's April the 27th of 2016. All right. Waldman, who's an attorney for Johnny Depp, is making these statements. Now, I want you to think about how you might understand these statements. Do you understand them as opinion? Do you understand them as fact? Do you understand them as opinion, but implying fact? Right? How do you understand this? Given knowledge that was available in 2016. Right? Because again, we have to go to the time that they're made about whether defamatory or not, right? So let's read this and, put ourselves into a, imagine in particular, like, right? Because you have to assume the ordinary common reader, right? Anyone who reads this. So you can't assume the person who's reading this knows particularly anything about the Johnny Depp Amber Heard saga, like at all, right? They probably know who Johnny Depp is, and they might know that Waldman's the attorney, right? And they probably don't have any specialized knowledge. So what do they understand this statement to mean? Okay, this is how we think about things. Now let's consider, quote, quite simply, was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouse, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their story straight under the direction of a lawyer and publicist, and then placed a second call to 911. Yeah, I hope you're at least seeing the potential problem. Right? I'm not saying this is necessarily, I'm hoping all I'm trying to show you at this point is the potential problem. I hope you can see the potential problem. When read in isolation, this arguably could be interpreted as a factual statement. When read in context, however, it's non-actionable opinion. Importantly, Waldman's statement is present as a statement by a lawyer in the context of litigation, which kind of cuts both ways at best. It is presented in the article as a lawyer in the litigation. That goes to his bias, but also might go to his knowledge. So, and necessarily represents only one side of a heated debate. This is not really debate in the sense that the courts seem to use that term Further, it was made to a reporter who presented quotes from both sides of the debate and was necessarily aware the facts were hotly disputed. Okay. Indeed, the article quotes Ms. Heard's attorneys referring to Waldman's statements as fantasies. So they're saying it's not facts. But then again, what does the reader understand? Mr. Waldman never claims to have personal knowledge of what happened. Yeah, but he's an attorney, so, And Mr. Depp and Ms. Heard share a penthouse, and no one disputes this. Rather, it's clear that Waldman is speaking as a legal advocate and offering his own interpretation of disputed evidence. I mean, that's one way to parse it. It's one way to parse it. The problem, as I've been trying to emphasize a couple times at this point, is our posture on appeal. This is our problem, right? We're on appeal now. So we're looking for reasons to say yes, not reasons to say no. This is our problem. Our job as the appellate court is to assume everything that happened at the trial court is fine. Now, maybe it didn't. That's why we're here. But we're going to interpret any ambiguity or unclarity or uncertainty in favor of the trial below. Because the trial judge was there. The trial judge was there. They saw the parties. They saw the witnesses, right? We, the appellate court, didn't see any of these things. All we have is a cold record. We don't know anything about the Amber Heard trial. Never heard about it, right? We're just reading a cold record and don't know anything about this trial, right? And so we're certainly looking for mistakes, but we're going to interpret any sort of unclarity in the trial court's favor, in the jury's favor, in the verdict's favor. So is this a reasonable interpretation of the facts? Yes, it is, but it's kind of contrary to what the jury did. And so we have a bit of a problem, Waldman's statement is thus most reasonably understood. Maybe most reasonably, yes, but the question is, just because it's the most reasonable, is the alternative possibility unreasonable? That's the problem, right? We don't need to prove this is the most reasonable interpretation. What we need to prove is that the other interpretation is unreasonable. Is it the most reasonable? Maybe. Is the other one unreasonable? So the most reasonable interpretation is that it's in the conflicting evidence as a he said, she said, and cannot be defamatory. That might be the most reasonable, but is the other view unreasonable? No liability when there's no first-hand claim of knowledge of fact, and the context and tenor of the article suggests it reflects the writer's subjective and speculative supposition. Writers must be given some way to be offered interpretation of ambiguous sources. No liability in defamation statements by attorneys were a subjective assessment of the evidence. Okay, so this is from the Eastern District of Virginia, so that's federal. But hey, that's something. So maybe. So this is promising, from the Eastern District of Virginia, federal. No liability in defamation for statements by an attorney that were subjective assessment of evidence, which it could not have been objectively characterized as true or false at the time, as depend largely on perspective and assessment of the weight of available evidence. That's really good authority. I like that. That's pretty good authority. The Virginia courts are not extremely well known for caring a lot about what the federal courts say about the interpretation of their own state law, but hey, it's better than nothing. Some citement from Virginia: no liability for defamation for accusing a plaintiff of lying when a reasonable person would have perceived the statement's pure opinion. Yeah, it's not quite our factual picture here. In context, it's clear that each of the statements, including April 27th Waldman statements, reflects a subjective view and interpretation of theory, conjecture, or surmise, so as to be non-actionable opinion. Is it clear? I mean, I don't blame them for trying, and they could absolutely win this. I'm not saying they can't win, but it's not like they're not showing, for example, it's against the manifest weight of the evidence. There was 10 people who said this, and only it's against manifest weight. No reasonable person, it's a little Catry gives $5.99 in euros. Say, I'll have to catch this as a replay since you're streaming in the middle of my night shift, but wanted to thank you for this anyway, and thank you for your hearts. I appreciate that. So yeah, they could win. They could win. It's just a little, let's just say argument one is best argument, which also for me as appellate court is really, really convenient because I can decide on issue one and then stop writing. That's like, you know, because issue one is dispositive. It's dispositive. It's a pure legal issue. If Johnny Depp can't be held responsible for Waldman, then nothing else matters. So for me as appellate court, this would be great for me because I'm like, well, you win on issue one, issue 2 and 3 are moot, go away. Amber, you lose. And I don't have to decide issue 2 and 3. Yay. Issue one is by far best issue. It's in accord with Virginia law. It's in accord with Virginia law. It's in accord with majority jurisdiction. Issue one is best issue. Issue 2 and 3 leaves a little bit to be desired. I still think, at least in my opinion, and not that I've done the complex legal analysis to go through it all the way, but for my money, I think there's not enough daylight. It's better issue than 2 or 3. So again, like, it goes to show what different lawyers like different things, right? I totally agree issue 1 is the right issue. I totally agree issue 1. But I might dump one of these other issues or consolidate them to bring in this other issue about daylight. That there's not enough daylight for it to matter. I think it's a better issue. It's also a more pure legal issue, which is nice. So different lawyers have different styles about things. Glow T gives $4.99, says you're always the best. Well, thank you. Generous says off subject, but I'm impressed about the variety of shirts, Kurt. I know, it's a good job having more than 5 shirts. My Jim had about 5 when I met him. I had to help him out. Thank you. I've got like 20 something polos. I do wear a lot of blue because blue is a good color for me. I've got like 7 or 8 different blue ones, but thank you. I appreciate it. Kurt's chat is best chat. Issue 1 is best issue. Runs about where we're sitting. Mr. Waldman indisputably had no personal knowledge of what happened. As set forth, the evidence presented at trial shows that Waldman subjectively believed, based on evidence, they had collected and reviewed that, and this is also weaker than 2. This is weaker than 2. I would be more willing to rule in Johnny Depp's favor on issue 2 than issue 3. So if you're trying to sort this by strength of argument, they sorted it in the right order. 2 is a stronger argument than 3. This is weaker. I would have brought daylight before I brought issue 3. And I would have flushed out issue 2 a little bit more. Needed a little bit more help. Another pass or 2. I think number 2 could be better. It's just it could be a little better. I don't know. It's too much setup, not enough discussion. A few choice quotes from the deposition or something would have gone a long way, in my view. Waldman was merely drawing inferences and speculating based on evidence available to him, but the problem is the evidence available to him is not the evidence that's available to the normal person. That's part of the problem. What happened on May the 21st? The reason good faith interpretation, see, again, of the evidence cannot be defamatory. The trial court error. Just because, this is a problem. Just because, I'm not saying the reason good faith interpretation isn't what you said. The problem is the converse isn't necessarily true. That's the problem. This is the problem. Yes, a reason good faith interpretation is what you said. The problem is the other opinion a reason good faith interpretation? And I'm not convinced it's not particularly based on this. So anyways, okay. So let's discuss the denial of jury instructions. Jury instructions are renewed under abuse of discretion, which is really, really fucking hard. In reviewing a trial court's decision to refuse jury instructions, the evidence viewed in light most favorable to the proponent of the instruction. When the content of the instruction is an accurate statement of the relevant legal principle, that's a question of law. Like all questions of law, it's subject to review de novo. If a proffered instruction finds any support in credible evidence, refusal is reversible error. Okay, so our standard of review is a little bit different here. Fine. Where our standard of review is a little bit different. So in interpreting the jury instructions, we're interpreting the evidence in light most favorable to the proponent of the instruction. So now we are changing our view, right? Now we're changing from the interpretation of most favorable to the verdict to most favorable to the instruction, right? So this is, we have to change perspectives at the Court of Appeals, right? And this is fine. We can do that, right? We have to change perspectives, and we do it all the time. Sometimes it's abuse of discussion. Sometimes it's clear error. Sometimes it's in view of the verdict. Sometimes it's in view of this thing, right? So it's like we gotta shift our perspective, put ourselves from a different vantage point. Fun and exciting for everyone. All right, let's do that. Let's put ourselves in the vantage point of the instruction. Okay. Evidence was present from which a jury could have found that Waldman was independent. I think this much is very much true. At trial, Depp proposed jury instruction number 22. An independent contractor is a person who's engaged to produce a specific result, but is not subject to control of the employer principal as to the way he brings about that result. If you find Waldman was acting on Depp's behalf, but was not subject to Depp's control as a manner, method, or means, you must find that Waldman was an independent contractor. That sounds pretty good. 23, apparently. An outside lawyer retained by a client in connection with litigation is an independent contractor. That sounds good. 24, a person who hires an independent contractor is not liable for an independent contractor's actions if you find that Waldman was an independent contractor instead of an employee. You may not find Depp liable. The court denied these instructions. These seem like mistakes. It seems like these are good instructions. I'm okay. And there seems like there's evidence to support these instructions, so okay. Mr. Depp incorporates by this reference. I will not repeat at length the argument above, thank God. In sum, since the evidence supports a finding that Waldman was an independent contractor whose allegedly tortious conduct cannot be imputed, absent evidence of additional development. The evidence presented at trial meant that Waldman represented Depp solely as an attorney in various litigation. As such, the court should have adopted the majority position of jurisdictions. But where are these coming from? Oh, these are just, okay. These are not model rule instructions. I was confused for a second. I thought these were model rule instructions. Well, I'm like, why didn't the court admit these? Now I understand why the court didn't admit them, right? And is it an abuse of discretion? No. Because, yeah, I don't, okay. This might be the correct statement of the law. But as the appellate court, like, I'm probably just going to dispose of the whole thing. I'm not going to remand it. Because the overwhelming light is like, no. Yeah, okay. I thought these were model instructions. I was really confused about why they weren't giving them. The evidence at trial established that they represented as such the court should adopt the majority position. Yeah, well, the trial court didn't do that. And the trial court, I think, was probably on balance correct. And the Court of Appeals might want to change the law. And I guess could send it back in that light, but probably should just dispose of it and call it a day. In the court declines to adopt the per se rule, evidence was presented from which the jury could have reasonably found. Yes. So, right. So this is an argument in the alternative, right? First of all, how about just per se? How about just flat rule? How about just no? We're giving the Court of Appeals another option. Okay, if you don't want to say no, you want to say maybe, then we need this instruction so the jury can find it. Personally, I'm quite happy with the per se rule. So I don't need this, but you know, that's me. That's me if I'm deciding this case as the Court of Appeals judge. I'm happy with the per se rule, it's fine. So yeah. For instance, Waldman testified that he's the owner and managing member of his own law firm. He offers legal services and Depp is not his only client. Accordingly, the trial court erred. Okay, yeah, so if I was inclined to not make this per se and send it back, then sure, but I'm definitely not inclined to do that, so, you know, all right, fine. All right, so now let's talk about an evidentiary problem. A trial court's decision to omit or exclude evidence is reviewed under abuse of discretion. Yes, it certainly is. Trials are in control of their trial management. They're in control of what witnesses testify for how long and so forth and so on. And so the trial court's decision not to allow evidence is subject to abuse of discretion. It's really hard. Let's give it a shot. At trial, Mr. Depp sought to introduce unredacted copy of the 3 Daily Mail articles, consisting of which each of the statements. The court excluded the Daily Mail articles as hearsay. I don't think that's right. They're not really shown for the truth of the matter asserted. They're being shown to show how a reader would understand the context of the statements. Their truth is not. I don't think hearsay is right. The court's apparent reasoning was the Daily Mail article was written by a reporter, not Waldman. So the context that matters is the context in which Waldman made the statements to reporters, not the context in which statements appear. Yeah, that seems wrong. That seems wrong. As set forth in section 4, in assessing whether a statement is actionable, context is paramount. Correct. While the context in which Waldman made the original statement is relevant, the content of the article is relevant. For instance, the full articles in which statements appear are relevant to how the reporters and ultimately the readers understood statements. Yeah, exactly. It's not hearsay. It's not being offered for the truth. Those statements are not being offered for the truth. They're going to understand the impact. They're going to the impact on the listener, not for their truth. I tend to agree. Further, the statement in the article contains additional quotes from Waldman that put his statements in context, identifying the evidence he's interpreting. Okay. The full article in which Waldman's statements appeared and relevant to assess damages purportedly sustained from them. And assessing whether the herd suffered any damages, the jury should be able to consider. This is a pretty fucking good argument. This is a good argument, guys. I mean, abuse of discretion is really hard. But this is a pretty damn good argument because it goes right to the heart of it, right? It goes right to the heart of it. The most important piece of evidence is the article. Those are where the quotes are. It's the singular most important piece of evidence. How a listener understood the quotes is obviously impacted by the article in which the quotes were contained in. So, like, if you're looking for abuse of discretion is really, really hard. But I think you're there. I think you're there because it's not hearsay. It's not being offered for the truth. It's being shown for the impact on the listener. And it's the singular most central piece of evidence in respect of the claim. Yeah, that's a big boo-boo. That's a big boo-boo. Yeah. In assessing whether Heard suffered any damages, the jury should have been able to consider the context were buried at the bottom of salacious tabloid articles and surrounded by substantial additional commentary. Trial court erred in excluding. I think they did. Ugh. Which is another reason for me as an appellate court, if I weren't already inclined before to make it a per se rule. Because now I don't have to send it back for them to correct the error. I think they made a mistake. I think it's a big one. Conclusion should reverse. Yeah, I'm good for reason 1. And if I side for reason 1, I can decide this issue 2 and I still don't have to send it back and I'm happy. Respectfully submitted by Ben Chu et al. Well, my assessment is that issue 1 is best issue. Issue 2 is a little underdeveloped for my taste, a little conclusory. I think they can get there. I think they could get there in issue 2. I'm just not sure they did get there. That's to my reading, right? I'm giving my assessment, which I suppose is always implicitly true. But I felt like they could get to where they wanted to be, but they didn't get there. I wish they'd had a little bit more, some quotes from the deposition, a little quote here or there would have gone a long way, or a little less in the theoretical and something a little bit But and then issue 3 feels like a bit of a loss because the problem is they keep saying why their perspective is reasonable perspective, which is the wrong argument. The argument isn't why their perspective is reasonable perspective. The argument is why other guys' perspective is unreasonable perspective. And they failed to accomplish that in number 3. So number 3 is a no for me. Number 2, number 1 is the winner. Number 1 is winner, chicken dinner. And then this issue on the clear error. Clear error is really hard. Trial courts get a lot of discretion. But this is the central piece of evidence. It's the most critical evidence in the case. All defamation has to be understood in its context. So denying entry of the article seems like a big miss. That's a big miss. So yeah, if I'm appellate court, I'm deciding for rule number 1 and then saying, okay, everything else is stupid. And then also saying, yeah, you kind of screwed up on 4 and it doesn't matter because I already decided for some other issue and go away. But that's what I'm thinking. But you know, that's my assessment of the case. That's my assessment. And I still think the idea that the defamatory statement isn't defamatory enough is still a good argument. So I think over 3, because I don't think 3 is winnable. I don't think 3 is winnable. 2 is winnable. I just don't think it was well developed. I don't think 3 is winnable. So I would have dropped 3 and brought an alternative argument. There's not enough daylight between the defamation and the pleaded truth for it to make a difference. You know, based on everything that's assessed. That's a better argument. I'm not saying it's not better than 1. It's arguably not better than 2, but it's better than 3. So that's my assessment of things. Life applies. Is there any way I can submit an idea for stream? Sure. You can tag me on Twitter or send me an email or stuff. Yeah, people send me ideas not infrequently, but you know, sometimes, you know, I take a look at them and sometimes we'll see if they're any good. So what were numbers 1, 2, 3, and 4? There was no 4. Well, I mean, we can go back to the table of contents. It's the easiest way to show you what 1, 2, and 3 were. Yeah, so 1 was Waldman is an independent contractor. 2 is Heard presented no evidence of Waldman's actual malice. 3 is in context, the Waldman statements are not actionable. That's 1, 2, and 3. And then 4 is this clear error thing over here. So I would have not done C in discussion. I would have not done C. I would have flushed out B a little bit more. I would have not done C. I would have replaced C with something else. But that's me. Did I ever go to my mail? I did. I haven't gotten the Tiger yet, but I went to my mail yesterday or the day before. I got a Black's Law dictionary and I got a Magic 8-Ball, which were appreciated. Haven't gotten the Tiger yet, but soon. Thank you, Sandra, for saying it's brilliant in my insight. That's fine. Yeah, I would have replaced C with not enough difference between the plead statement and actual truth. Yeah. Yeah, I would have replaced C with that. Yeah, I don't think C is winnable. I think there's a better argument to be had. C goes to the error. No. A in discussion under standard review is more in line, or the articles provide necessary context is more relevant to A than C, in at least the way it is from my mind. Ask the 8-Ball if Depp will win. I could do that. What else can we talk about, guys? I have a couple minutes. Amber Heard has requested a time and page limit extension, maybe. Yeah, perhaps. She does have more errors. She has a lot more things that she needs to raise. Depths are tighter. Amber Heard has gone through this completely scattered shot thing. She's raising so many errors that if she's limited her page limit, she's not going to have time for it all. So we'll see what's happening. When's the bar admission ceremony? It's supposed to be on the 14th, but I don't know that I'm going to be able to make it, unfortunately. So we'll see. Odds on page limit being decided? I couldn't know. I don't know. Any thoughts on the horrible, awful New Mexico trial where testing evidence takes too much effort? I've been seeing a little bit of that, and based on what I've seen so far, it's not been great for the prosecution. The prosecution's case has been kind of, yeah. I've seen some of it. The witnesses for the state are like, yeah. I suppose I filed for the bar application a little bit late. I guess I didn't realize how much. I filed for the bar application in April, and by rule, the Texas Bar Board examiners has 270 days to conduct character and fitness review, which would take us to January. So it doesn't look like I'm going to be cleared in time for the ceremony, which is a little bit annoying, but that's okay. If I get cleared at some later time, then I will just pester one of the Supreme Court justices of Texas to swear me in privately or something and film that, and that will also be hilarious. So I am not dismayed. I'm a little annoyed, but you know, it's okay. We'll press on. So it was supposed to happen. So it was supposed to happen November the 14th, but I don't think it's going to happen. So, oh well. What's crazier, Suitcase later or OnlyFans? I think Suitcase is crazier. I think Suitcase is crazier. Can I go to the next ceremony? What, in like June? I suppose I could, but why? They only have the bar exam 2 a year, so there's only 2 ceremonies a year. So like, do I want to wait till like a next year? Not really. No. Parkland shooter, death or life if I chose? For the Parkland shooter, death, of course. I mean, he shot how many people to death with malice and intentionality? The fact that he's going away to rot in some cell also is not a bad result. You know, the fact that he'll watch the paint dry on a cell wall and be forgotten is not a bad result, but it's not what he deserved. I'm going to lie. Yeah, 17 killed. Yeah, exactly. Exactly. I just got a notice from the Associated Press that an appellate court apparently ruled against a transgender person's ability to compete in a beauty pageant. That sounds hilarious. Maybe I'll do that tomorrow. Do a live review there. Yeah, 17 killed. So yeah, I mean death for sure. For sure. But what type of law am I performing in Texas? I'm not performing any type of law in Texas at the moment. And I'm not planning on performing law in Texas anytime in the near future. I'm planning on continuing my YouTube channel and being with you guys. It's great. The suitcase murder is really disturbing. Getting the boyfriend in a suitcase, zipping it closed, and then she tapes it. She's doomed, man, I would think. She's doomed. She videotapes the whole thing. She videotapes her zipping the boyfriend into the suitcase, him begging for help, pleading to be left out, and then leaving him there to die. She's toast, man. That's messed up. That is screwed up, man. The fact it's on videotape, man, she's toast. The Texas bar was for the challenge of it. It's to give me options in the future. It's to give me options. It provides me flexibility, you know, because if I want to practice in Texas, you know, because I don't really plan on going anywhere. And also, my scores are now transferable to like 40 other jurisdictions for some period of time. So if I want to go, if I get a job like in the next year or two, I can transfer my scores basically to pretty much every other state and get sworn in there. So I passed the bar basically in like 40 states simultaneously because that's how that works. So it will give me my license in Texas and also gives me an option to extend. It's not an infinite time length, right? The time length is somewhere between like 2 and 5 years, depending on jurisdiction. But if I want to go to basically every jurisdiction except for Florida, Georgia, California, Louisiana, I think Hawaii, I think South Dakota. If I want to go to like any other jurisdiction other than those, my scores are transferable. So it's pretty nice. Nevada, maybe. Yeah, maybe Nevada's not on the list. I'd have to double check. And she was laughing in the video. Yeah, she's going down hard. Thoughts on the Safety Act here in Illinois? BS. Charlene Paul says, I love to hate your content. Sometimes I love to love it. I'm not sure how to interpret that comment. I'd like to think my content is always lovable. But I thank you for watching anyway. Thank you for your super chat. How did the lady get the boyfriend in a suitcase? I'm not sure about that part, but it doesn't really matter. I'm not sure how she got him in there. Maybe it was a game and then she said to be left out. I mean, it doesn't really matter how she got him in there. She left him in there confined, alone, and he died, so. It shows the video she taped. Oof. Man, that's rough. You know, we're playing. And he's begging for his life and she goes upstairs and abandons him. Oof. Laurie, yeah, Valo Daybell's on pause. Valo has again been adjudicated mentally unfit to stand trial. Again. And Daybell had his motion to extend granted, so the case is on pause for the indefinite future right now. So I don't know we're ever going to trial on Valo Daybell this case. Yeah, it's a thing. The video is brutal with him begging. I bet it is. I bet it is. How scary, how terrifying for him. How horrible. That's nightmare fuel there, guys. That's just nightmare fuel. Mama Jane says, if you're transphobic, just declare it now, please. Well, I don't know what that means to be transphobic. Does that mean to disagree on trans issues? I don't know what that means. I'm a biological essentialist. Is that helpful? Did I meet the voter registration requirements for my new district? Yes, I did. What's my favorite theme park that I've ever been to? Universal Studios in Florida. Kick ass. Jennifer says, Kurt, I commend you on continuing to educate yourself. I try to learn new things every day. It keeps you sharp and out of trouble. Not you get in trouble tucking in your horns under your hat. What are my thoughts on the Indiana merger of two girls being sealed? For the charging documents, depending on where they are in the case, it might not be that unusual. I'm not sure why they're sealed now, but yeah, I don't know. I don't have enough information. We can hang out some more. I could get a beer and we could just chill for a while. I like hanging out with you guys. It's good for the engagement. I'm a biological essentialist. I believe that men and women, the terms are biological. That's what I think. Are you doing part 2 of affirmative action? Good question. Probably tomorrow. During the day sometime. Probably early evening, maybe 5 o'clock tomorrow. Is my AC broke? No, I'm very comfortable. Any thoughts on the teen in Iowa killing their teacher? I'm not sure. I'm familiar with that. Anything more? Legality of annexing Canada? What, by force? Well, if Canada says yes, then it's totally legal. If Canada says no, then we have to conquer them. So, yeah. Thank you, Charlene Paul, for becoming a member. I appreciate hitting the join button. Any new soundboard stuff that I've discovered? Not so much on the soundboard, but I did get the lights set up so that I have a button to just change the lights by pressing one button, and it selects a random triad. So I can just change the lights by pressing a button. It's pretty cool, right? So it just selects one out of the 12 triads. That's cool. NFA violates the Second Amendment or not? I'd have to read the details of the NFA. I'm not sure if I've ever read the NFA all the way through. But it probably in part does. But in total, I don't know. I'd have to read it. But it wouldn't surprise me if part of it violates it, but does it all? I don't know. They tried to serve boozy and they dodged. I heard that. Also, the Florida judge hugging the prosecution in the Cruz trial, not a good look. Not a good look. Did I talk about Amber's domicile argument? It's the Amber domiciles argument is in the federal case dealing with diversity jurisdiction. Since she was domiciled at the time the lawsuit was filed, I don't think it's going to work. It's not relevant to our immediate discussion, but we did discuss it a little bit. Am I going to do Lawyers and Dragons again? I haven't been invited back. I haven't been invited back. Bottom line. Anything new on Amber being stateless? There's no new discussion on that yet. Thoughts on expanding the number of Supreme Court justices? If we did it in some sort of gradual way, like we added a new seat like every 4 years or something, then maybe we need a bigger court because of the amount of cases that are being heard or something like that. But I wouldn't be open to just giving one party or the other like 5 new seats, and that's not good. What's my unvarnished sober thoughts on Jackson so far? Not great. Not great with Jackson, but you know, we'll keep trying. Can Washington, D.C. be granted statehood? It creates problems. It creates problems. It would be easier to retrocede DC into Maryland, but neither DC nor Maryland wants that. That'd be the easier solution. It also is technically a violation of the land grant from Maryland in the first place. Who's the president of Puerto Rico? Lol, cute. DC would bankrupt Maryland? I don't know about that. Dallas is the headquarters for Mary Kay, so there might be some hot independent business ladies there. That's cute. Well, I guess I'm going to sign off for now. The chat seems to have died out, and DC would raise the crime rate in Maryland. Yeah. I'm going to sign off for now. If you've enjoyed the stream, please remember to do all the YouTube things, like, comment, subscribe. I've been on Uncivil Law. Why does it take $10,000 to print SCOTUS documents? That was a little overestimate. The actual printing cost to print is probably not $10,000. It's probably more like, it's a couple $1,000s at least to print the documents. The reason is because you have to print like 23 physical copies of them, and they have to be printed in this really specialized paper, and you want to look really, really nice. So it takes a lot of money because the Supreme Court can't use regular paper sizes like a normal person. They don't use 8.5 by 11 or 8.5 by 14. Their paper size is like 6 3/4 by like 7 1/8 or some bullshit that no one uses. So it's a pain in the ass. But yeah, the printing cost, $10,000 is an overestimate, but it would cost a couple. It would be expensive to print. But anyways, I'm gonna sign for now. There was actually one case where a lawyer had to buy this. Is there a small firm? That's funny. All right, I'm gonna sign for now. Until later, my friends. Hope you're all's well. Cheers. Bye.